Hi guys, this is Mr. Tan, and today we're looking at the Health and Safety at Work Act 1974, and we're looking at the health and safety laws for the UK in general terms. I mean, this is really important because failure to comply with the health and safety laws can result in both civil and criminal penalties. As an employer, if someone has an accident at work or is made ill, a health and safety regulator can actually prosecute that employer for a criminal offence. And also, if the person who has actually got ill, the employee, can also take a claim in terms of the civil side to that employer. Even if no one has been harmed in that organisation, it can still be an offence against health and safety offences in terms of the possibility of a risk happening if things are not actually in order. When we look at the legislation, we're discussing the Health and Safety at Work Act 1974. And this legislation sets out the framework for managing the workplace health and safety in the UK. And the Act kind of defines the general duties of everyone from employers, looking at Section 2, and employees looking at Sections 7 and 8, to owners, managers and maintenance of work premises for maintaining health and safety within the workplace. For the business sectors who operate in a higher risk environment, such as construction, chemical manufacturing or nuclear, there are further legislation that is required for those specific workplaces. But as a brief overview, the HAS AWA 1974 requires the workplace to provide adequate training to staff to ensure health and safety procedures are understood and adhered to ensure that adequate welfare provisions for staff at work are taken into consideration, a safe working environment that is properly maintained and where operations are conducted safely, and also suitable provision of relevant information, instruction and supervision. I mean, even if we look today with COVID and we talk about adequate welfare provision for staff at work, the place where I work, LCCA, they have implemented half a day that staff can take off once every 2 weeks in terms of stress related due to COVID related issues. Again, this is being looked at from a HR perspective in terms of making adequate welfare provisions taken into considerations of what's actually happening today. When we think about the workplace health and safety welfare regulations 1992, these regulations apply to all aspects of the working environment and require employers to provide a workplace that is safe and suitable for all work activities. I mean, this includes providing break areas, washing facilities, drinking water, as well as appropriate lighting, ventilation, and space at work. Safety provisions must also take into consideration, including property maintenance equipment, floor spaces, and protection from possible injuries. Again, if we think about COVID and we think about the ventilation, we know that this virus is transmitted through the air, so we can breathe it in, hence the reason why everyone has been encouraged to use masks. And companies now have to make sure that the ventilation is properly circulated with air from the outside and not just recirculating the air from within the building. If we look at the DSE regulations 1992, then we're saying to ourselves, well, this relates to the display screen equipment, and the display screen equipment regulations define relevant workers for those who have to use these display screen equipment daily for an hour or more at a time. So this includes those working with computers, laptops and smartphones. So employers must take steps to protect those workers from the health and safety risks of working with display screens. So employers must carry out a suitable DSE workstation assessment, must reduce associated risks, including making sure that workers take regular breaks from display screen equipment work, and provide auxiliary equipment if required, provide free eye and eyesight test upon request from a DSE user, and provide relevant training and information from DSE users. Now, when we think about the management of health and safety regulations 1999, then the law explicitly states what employers are required to do to manage the health and safety under the Health and Safety at Work Act 1974. And the main requirement of employers is to carry out a risk assessment. If you have 5 or more employees, you are required to record the significant findings of your risk assessment. So, the office environment's risk assessments don't have to be complicated, but employers must include a report of any shortcomings in health and safety arrangements, a report of any dangerous situations, the use of equipment in accordance with training and instruction, and to take reasonable care of their own health and safety and those of others who may be affected, by their acts or the admissions. So, the reporting of injuries, diseases and dangerous occurrences regulations 2013 RIDDOR, here in this legislation here, it says certain cases of workplace injuries, illnesses or instances must be reported on the RIDDOR. Employees should report accidents and incidents to their manager. Employers, managers and supervisors have a legal obligation to correctly follow reporting procedures, and reportable incidents include fatal and non-fatal injuries, occupational diseases, dangerous occurrences, often referred to as near misses, and incidents that result in more than 7 days absence from work, including instances involving gases. So again, all these need to be adhered to according to the reporting injuries, diseases and dangerous occurrences regulations 2013 RIDDOR. So again, very, very important for the employers to ensure that they carry these out. And just going back to what we said in the beginning in terms of possibility of criminal and civil proceedings, again we can see the examples here in terms of waste and recycling company fined for safety filings. We can see a metal supplier fined for after employee suffers multiple fractures. A whiskey distiller fined after an employee was killed. A plant hire firm fined after employee suffers serious injuries, and a roofing company fined after worker suffers fatal injuries in a fall. And this can also lead to criminal proceedings and against directors of a company or failing to carry out their appropriate legislation. So again, very, very important that employers and directors responsible for these to make sure that they are carrying out the contractual and legal obligations according to legislation.